Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Hello, everyone. Not so much immigration news this week, although the Biden administration did announce the date that it will start accepting applications for its new parole-in-place program. Exciting stuff. I thought this was interesting, though. The excellent counsel on the first case I'm going to discuss out of the First Circuit alerted me this week that the 8th Circuit's Barahona decision from episode 41 is the direct appeal of matter of Werb, the BIA's decision about Interpol red notices. And if I'm not mistaken, Barahona vacated the underlying BIA decision and remanded it back. Neither Lexis nor Westlaw seem to indicate that this happened, and matter of Werb is an acronym, so it was hard to piece it together that it's actually Mr. Barahona. But that's what the B stands for. In Gonzalez-Castillo v. Garland from episode 123, the 9th Circuit explained, and I missed this, that, quote, the 8th Circuit addressed and rejected this reasoning in Barahona v. Garland, in which it granted the non-citizen's petition on direct review of the published Werb decision, end quote. Restated, matter of Werb is zombie precedent. So think about that next time it's brought up to support DHS's argument about Interpol red notices. Also this week, and I just love when this happened, I received an email from Mark Bristow, the U.S. citizen plaintiff in the Bristow v. Mayorkas decision that I discussed on episode 208 about challenging INA Section 204C findings in federal court. If you'll recall, Mr. Bristow and his non-citizen husband Felix Berto won that case. The federal district court sent it back to USCIS for further adjudication. And well, this week, Mr. Bristow emailed me, informing me that he had listened to my summary, and that, quote, my husband gets his green card in the mail next week, end quote, with a smiley face. Congratulations to Mr. Bristow and Felix Berto, and of course, his exceptional lawyers and their litigation. Keep the emails coming, everybody. And here are your 5 cases this week. Our first case is Paye v. Garland, published by the First Circuit on July 17th, 2024. This is a fairly long decision in which a, quote, litany of errors, end quote, were asserted. Get ready. Mr. Paye is from Liberia, a country where, quote, a civil war raged, end quote, during the 1990s. Quite the interesting summary of that war, which we unfortunately don't have too much time to discuss right now, but suffice it to say, President Samuel Doe was from the Kron ethnic group and committed notorious atrocities, and then Charles Taylor and his National Patriotic Front of Liberia committed horrible acts of brutality against Krons in retaliation. Quote, by October of 1990, roughly 2/3 of Liberia's 125,000 native Krons had fled the country to escape the NPFL and INPFL, end quote. Charles Taylor then became president in 1997 and served through 2003, during which the, quote, ethnic cleansing and genocide for crimes continued, end quote. Charles Taylor is now in prison for crimes against humanity, by the way. Mr. Paye is, you guessed it, of Kron ethnicity. Born in 1990, he spent his childhood living in Sierra Leone and Guinea refugee camps and fleeing persecution in those countries, for the ethnic cleansing spread outside of Liberia. Indeed, when a child, the family was stopped at the Ghanaian border, and Mr. Paye was hit with a rifle butt, causing permanent damage to his ear and hearing. Thankfully, Mr. Paye was able to enter the United States as a refugee at 15 years old in 2005. He became an LPR in 2010 under the Special Asylum Adjustment Provision, retroactive to 2005. Why removal proceedings? Because in 2020, and not naturalized, he pled guilty to various firearm offenses. DHS alleged that at least one of them was an aggravated felony. Mr. Paye applied for asylum and related relief, but the immigration judge denied it. In addition to agreeing that he was removable, the IJ found that the crime was a particularly serious crime that barred Mr. Paye from everything except cat deferral. Then the IJ denied that, holding, essentially, that it's been a long time since all that stuff happened in Liberia, and that things look like they've changed. The IJ also made a no past persecution finding. After a bit of back and forth with the First Circuit, the BIA affirmed. But it eventually avoided the particularly serious crime holding and relied solely on a finding that Mr. Paye hadn't suffered past persecution and couldn't show future persecution or torture. And so to the First Circuit, it eventually arrived. The court went through some heady jurisdictional analysis and, content, got down to business reviewing. Kicking it off. And while it actually did happen here, remember, quote, petitioners need not suffer physical harm for their abuse to qualify as past persecution, end quote. Lots of other standards discussed too. Applying its standards here, the first argument was that escape from ethnic cleansing and genocide is itself past persecution. An interesting legal argument, although when I say it out loud, I really feel that it shouldn't be that interesting, and that asylum law has gone a bit astray from its original purpose of protecting those trying to escape genocide. Anyway, the IJ and the BIA never tangled with this argument, explained the First Circuit. Is forced flight from ethnic cleansing and genocide, especially when it happens as a child, past persecution? We must wait for the BIA to provide guidance on remand. But the First Circuit definitely believes it possible. Else, why remand? Next, recall that as a child, Mr. Paye and his family were attacked at the Sierra Leone-Ghanaian border. The problem for Mr. Paye, to the First Circuit, was that it believes that the IJ and the BIA correctly found that he hadn't sufficiently shown a connection to the Liberian government. Remember, this is a Liberia-based claim. Quote, that his assailants spoke Liberian English and could have been Taylor's forces who pursued him into Sierra Leone, end quote, is not sufficient to the court. As to future persecution, assuming no past persecution, well, here too the First Circuit punted a bit because it was already sending it back for the ethnic cleansing stuff, which if Mr. Paye succeeds on will provide him a presumptively well-founded fear of future persecution. The withholding of removal denial, though, was vacated in its entirety, and it was remanded. So there you go. And so, that means, as it always seems to mean when there's a wonky, long First Circuit decision with lots of novel legal arguments, congratulations Sang-Yeop Kim, Gilles Bissonnette, and Margaret Moran with ACLU New Hampshire, along with New Hampshire legal assistance, for the win. And there's this. Thank you, counsel, for sending this along when the decision was published. So it turns out ICE deported Mr. Paye to Liberia during all of this, which is pretty wild given the claims, right? But ICE violated the rules in doing it, and well, the First Circuit is not happy. Quoting from an accompanying order issued by the court on the same day of this decision, and it's a long one, quote, petitioner explained in his motion that he was removed to Liberia in violation of First Circuit Rule 18.01, which states that if the government has scheduled the removal of a petitioner, then the government will file with the court a notice identifying the earliest date upon which removal may be made. In response, respondent, the government, explained that petitioner's removal in violation of the local rule was due to an unintentional oversight, that it will facilitate his return to the United States if he prevailed on his underlying petition, and that requiring it to pay for his travel expenses could implicate separation of powers concerns. This is not the first time in which the government has removed a petitioner in violation of Local Rule 18.01. By no later than 5 p.m. on Friday, July 26, the government is ordered to provide to the court in detail an explanation of how and why petitioner was removed, end quote. And it seems how the government is going to find Mr. Paye, get him back to the United States, and pay for it. Under penalty of perjury. Yikes. Don't forget First Circuit Local Rule 18.01. And that is Paye v. Garland. Our next case is Ramos-Gutierrez v. Garland, published by the First Circuit on July 18, 2024. This case is about particularly serious crimes and nexus. Mr. Ramos-Gutierrez is from El Salvador. He entered the United States in 2013 and he brought an asylum claim in immigration court. He testified that beginning at 15 years old in El Salvador, he was regularly harassed by a sub-gang of MS-13. The sub-gang, Padilla Sin Ley, harassed everyone in the town. They wanted him to join. He refused and gang members beat him up. He told his parents, who reported it to police, but police did nothing. Gang members beat him up 2 more times, even hitting him with a pistol. Mr. Ramos-Gutierrez's brother reported that one, and police searched for and found one of the sub-leaders, Melvin, but they did not arrest him. There was even a court date where Mr. Ramos-Gutierrez had to appear in court before a judge, as did Melvin. Melvin admitted everything and left the courtroom laughing. He was ordered to pay Mr. Ramos-Gutierrez $50. Not only did Melvin not pay, but the gang tried to get Mr. Ramos-Gutierrez afterwards. He moved to his grandmother's home an hour and a half away. The gang continued to search for him. Just gonna stop right here and flag all of this for next time you have a Salvadoran gang-based claim. All tribunals have found Mr. Ramos-Gutierrez credible, and well, he just testified about what happens when you make a police report against MS-13 in El Salvador. You go to court, have to identify yourself, and ultimately, at best, the gang member is ordered to pay $50, and then you are at risk of getting attacked again. Anyway, back to Mr. Ramos-Gutierrez. 3 years later, he came to the United States. And good on Mr. Ramos-Gutierrez, or his counsel, for before the merits hearing, Mr. Ramos-Gutierrez was, quote, able to access Melvin's Facebook page and find pictures of him with weapons, end quote. Smart move. The immigration judge believed Mr. Ramos-Gutierrez, but didn't believe that he was targeted because of any membership in any viable particular social group. The BIA affirmed. After all, reasoned the agency, in paraphrasing fashion, matter of SEG and matter of EAG, both from 2008, would make such claims difficult. Not impossible, though. The First Circuit affirmed the agency. To the court, Mr. Ramos-Gutierrez's first proffered particular social group of, quote, a young person who has been beaten and threatened by gangs, end quote, was impermissibly circular. The group to the court is defined by the harm or threat of harm. I seem to recall a recent First Circuit precedent, dare I say Espinoza-Ochoa v. Garland, episode 192, that wouldn't make circularity a total bar to a particular social group's viability if, for example, a shared harm experience made the group socially distinct in the country. Not discussed here, though, and apparently not argued. But don't sleep on Espinoza-Ochoa. As to the second group, quote, a young individual in the country who has been targeted for gang recruitment, end quote, the First Circuit saw that as too amorphous. I guess the court doesn't see where the boundaries are on such a group, and as the panel explains, the First Circuit has often denied gang recruitment cases. In any event, explained the court, there doesn't appear a nexus to a particular social group here. Rather, the gang was targeting lots of people in town, it seems, for criminal reasons and to fill its ranks. The First Circuit summarily rejected other arguments and affirmed the denial of withholding of removal and Convention Against Torture Protection, and denied the petition for review. And that is Ramos-Gutierrez v. Garland. Final case before we take a break is Ortega-Cordova v. Garland, published by the Fourth Circuit on July 16, 2024. This case is about crimes involving moral turpitude, prostitution, and those who solicit such acts. Mr. Ortega-Cordova is not from the United States, and he entered without authorization in 2003. In 2012, he was charged and eventually pled guilty to solicitation of prostitution in violation of Virginia Code Section 18.2-346B, receiving a sentence to 90 days imprisonment with 86 days of that suspended. That brought him to DHS's attention, though, which initiated removal proceedings. Mr. Ortega-Cordova applied for non-LPR cancellation of removal under INA Section 248B, surely alleging that his U.S. citizen or LPR spouse, parent, or child would suffer exceptional and extremely unusual hardship if he was removed. But if that prostitution solicitation is a CIMT, he's barred from the relief. And IJ and the BIA so found, relying on case law from the 1940s, 50s, and 60s. For the BIA's part, it noted that the understanding of what is turpitudinous in society is and does change, but, quote, what has made solicitation of prostitution reprehensible is not the sexual act itself, but the commercial, exploitative, and transactional nature of the act, end quote. The Fourth Circuit affirmed. And I know there are strong feelings out there about prostitution, so just remember, court's words, not mine. The categorical approach applies, of course, and it is undisputed that, among other things, the Virginia offense criminalizes, quote, consensual conduct between two adults, end quote. Turpitudinous? People hire prostitutes for many reasons, argued Mr. Ortega-Cordova, including possibly a disabled person who, quote, may be unable to achieve sexual gratification with another individual without providing financial compensation to that other person, end quote. Turpitudinous? And apparently one poll shows that 49% of Americans want to legalize prostitution. So if the CIMT definition is tethered to society's views, how can it be turpitudinous, inherently base, vile, or depraved in 2024? Argued Mr. Ortega-Cordova. And of course, the Fourth Circuit no longer owes the BIA any deference on its prostitution CIMT precedent, I would think. Well, to the Fourth Circuit, citing other circuits and the BIA, quote, there remains a societal consensus that prostitution and conduct facilitating prostitution violate a moral rule that judges the commoditization of sex to be at the expense of both participants' dignity and humanity, and thus to be wrong or bad, end quote. Getting quite into it, the court explains that payment for sex, quote, can be understood to extricate and isolate the sexual act from its much broader role as a component of one of the deepest and most profound human relationships, one that is held together by a wide array of positive bonds, including love, joy, partnership, pleasure, sharing privacy and intimacy, and surrendering to each other the most private human aspects, end quote. Prostitution, quite literally to the court, quote, not only demeans the participants, but also the foundational relationship so meaningful to humankind, end quote. And it can lead to other bad things like drugs, believes the court. Now it's true that some counties in Nevada, the state of Maine, and many developed countries have now decriminalized prostitution. But to the court, decriminalization doesn't mean that it's not immoral. The First Circuit explains that there are many reasons to decriminalize prostitution that don't relate to the morality of the act or solicitation thereof. As to the disabled person hypothetical, quote, regardless of motive, the statutorily prohibited conduct remains contrary to a well-recognized moral norm against treating sex with another person as a mere commercial transaction, end quote. The panel really doesn't like prostitution. And the court held that soliciting a prostitute under Virginia law is categorically a CIMT. I can only imagine more cases like this will arise in other circuits, especially after Loper-Bright, and if nothing else, the court's analysis recognizes that the CIMT definition is a moving definition that changes as society's views of morality change. There were two more arguments quickly disposed of by the court. First, Mr. Ortega-Cordova made a complicated argument that, if I'm reading the very short discussion correctly, argued that a CIMT shouldn't bar a non-citizen from cancellation if the crime doesn't have a potential imprisonment term of more than 1 year. This is based in part on the fact that, as the legislative history apparently shows, Congress wanted the CIMT bars to apply to felonies, and the federal felony definition at 18 U.S.C. section 3559A requires a potential term of imprisonment of over 1 year, not simply 1 year, as the Virginia crime requires. Interesting argument for another day and another case, as the Fourth Circuit summarily deemed it unexhausted. In any case, the Fourth Circuit believes the argument, quote, flouts, end quote, the INA's clear language. Finally, yet another challenge to the fact that a single member of the BIA decided this case rather than a 3-member panel. Other courts have found that issue non-reviewable of late, but here it appears, at least to the Fourth Circuit, Mr. Ortega-Cordova never made a 3-panel request in his papers to the BIA. So that pretty much ended it. So Mr. Ortega-Cordova can't even apply for non-LPR cancellation. And that is Ortega-Cordova v. Garland.
Are you struggling to find and hire new talent that you can trust? Does the idea of onboarding, training, and managing virtual staff overwhelm you? Staffy's got your back. Staffy provides top-quality virtual staffing for immigration law firms, complete with HR support to free up your time from the hassles of onboarding, managing, and continuously training your virtual staff. With an entire team of professionals, including psychologists and mindset, task, and performance coaches, Staffy ensures your virtual staff has all the tools needed to help your law firm grow and scale. Visit staffy.cc, that's stafi.cc, and schedule a consultation to claim $500 off your first month of service. Or, of course, click on the link in the show notes.
Welcome back. Next is Vera Punin v. Garland, published by the Second Circuit on July 16, 2024. This case is about Form I-213s. DHS alleges that Mr. Vera Punin is from Ecuador. He was convicted of some pretty bad crimes for which he served a 25-year prison sentence. During his criminal imprisonment, which remains ongoing, DHS initiated removal proceedings. Now, no matter who you are in removal proceedings, DHS always has the initial burden to establish alienage by clear and convincing evidence. That is, that you aren't a citizen or national of the United States. Mr. Vera Punin, through counsel, put DHS to its initial burden, and didn't simply concede the issue. To meet its burden, then, DHS relied on a Form I-213, which is kind of like an immigration police report in which some DHS officer alleged, among other things, that Mr. Vera Punin was born in Ecuador and that he wasn't a U.S. citizen. The I-213 also mentions Mr. Vera Punin's alias and lists his alleged immigration history. This I-213 also referenced a bunch of acronyms for databases searched, as I-213s are apt to do. And if you'd like a summary of what all those acronyms mean that we're always seeing, check out footnote 3. Seems like the I-213 was pretty detailed. Mr. Vera Punin objected to admission of it, though. And without the I-213, well, how could DHS establish alienage? But the IJ admitted it, noting the various cases permitting admission of a Form I-213. Ultimately, Mr. Vera Punin was found removable. He didn't actually apply for relief and instead filed a motion to terminate, quote, arguing that the I-213 contained indicia of unreliability because, among other things, it did not identify any source of its information, end quote. And also, he argued, it didn't sufficiently establish his alienage. The IJ denied that motion in what appears to be a reasoned decision, and the BIA affirmed through temporary appellate immigration judge Manuel, relying on matter of Ponce Hernandez and presumably other BIA precedent. Which brings us to the Second Circuit. Before the Second Circuit, Mr. Vera Punin argued that the IJ's decision was far from reasoned. Indeed, the IJ didn't even reference DHS's clear and convincing burden, or, quote, adequately explain, end quote, the IJ's reasoning. The Second Circuit, however, agreed with Oil that it couldn't consider this argument because Mr. Vera Punin never made it to the BIA, unexhausted. You don't have to make the exact legal argument to exhaust in the Second Circuit, explained the court, but if the argument, quote, cannot be closely matched up with a specific argument made to the BIA, it has not been properly exhausted, and we cannot hear it, end quote. That's how the court read the record here. Mr. Vera argued before the BIA primarily that it was error to admit and rely on the I-213, and that the I-213 didn't establish alienage anyway, not that the IJ's decision was incorrect. Quote, a claim that the IJ made the wrong decision is not equivalent to the argument that the IJ failed to explain his decision, end quote. So no dice before the Second Circuit. And on to whether it was proper to admit and rely on the I-213. Kind of. Unfortunately for my interests, Mr. Vera abandoned that argument before the court and argued only that the I-213 failed to establish alienage by clear and convincing evidence. I'm sure he had his reasons, but that is a pretty difficult argument. The Second Circuit rejected it. Explained the court, the federal rules of evidence don't apply to the IJ and BIA because, quote, agencies are not courts, end quote. As such, IJs can rely on anything submitted that's probative and, quote, fundamentally fair, end quote. Yes, an I-213 is hearsay, explains the court, but hearsay is admissible in immigration court, and I-213s are presumed reliable under decades of case law. Unlike other humans, apparently, quote, public officials are presumed to perform their duties properly and generally lack a motive to falsify information, end quote. The BIA has explained that, quote, absent any evidence that a Form I-213 contains information that is inaccurate or obtained by coercion or duress, the document, although hearsay, is inherently trustworthy, end quote. Still a standard to meet, though. Scour the NTA and ask your client about his or her immigration arrest to make such arguments. Mr. Vera argument was that the source of the information in the I-213 was unknown, not that it was inaccurate. But that's not good enough to undermine the document, explained the court. And there were lots of other indicia of trustworthiness within the I-213 that don't rely on third-party sources. Once admitted into the record, and if not rebutted, the I-213 can establish alienage by clear and convincing evidence under BIA and Second Circuit precedent. Quote, evidence meets the clear and convincing standard if it places in the ultimate fact finder an abiding conviction that the truth of its factual contentions are highly probable, end quote. I-213s apparently do that. Faced with all this, Ms. Vera took the presumption of reliability head-on and argued that it improperly flips the burden of proof, which, remember, is DHS's. They get this presumption that the very document they create carries their burden. Sounds kind of weird, argued Mr. Vera. Not so, ruled the Second Circuit. To paraphrase, that case law has made it a bit easier for DHS to meet its burden of proof does not mean that the burden of proof has actually shifted impermissibly. Last, Mr. Vera challenged the temporary BIA member who decided his case, namely, the fact that temporary BIA member Manuel has served in that role for over 3 years. But the regulations only discuss EOIR's director's ability to appoint temporary members for 6-month terms. Well, as other circuits have similarly held, and recently at that, temporary BIA member Manuel's appointment and perhaps reappointment was done by the Attorney General himself, or his designee. And the Attorney General has broad powers to do so. It seems like when that happens, there's no limit on how long a temporary BIA member can be on the BIA, temporarily. The 6-month regulation thing only applies to EOIR's director. It's weird, but it's what the courts have been holding. Long, wonky decision that required the Second Circuit to conclude with a 4-number bulleted summary of what it had just held. Hope you enjoyed. Mr. Vera I suppose, will remain in prison for many more years and then be removed. And that is Vera v. Garland. And so we come to KC v. Garland, published by the Second Circuit on July 17th, 2024. This case is about past persecution. Threats, to be specific. Mr. KC, not an acronym, is from Nepal. He testified in immigration court that supporters of the Nepal Communist Party, known as Maoists, persecuted him for his refusal to support their cause. See, he was in Nepal's army, like his father before him, and he even worked on a UN peacekeeping mission. Maoists targeted him when he returned from that. 10 or 15 of them appeared at his family home and demanded money and that he join them. When he refused, they said join or die. The pressure continued over the phone and at his home. On multiple occasions, they said they'd kill him if he didn't join. They were particularly interested in him because of his army training. His uncle told him in September 2014 that they were plotting to kill him that day. He fled, and his wife confirmed that they then showed up looking for him at the house, threatening to kill him. Police refused Mr. Casey's attempts to make a report. He remained in Kathmandu away from the Maoists for about a year, and he came to the United States when he learned that they were still looking for him and threatening to kill him. Indeed, Maoists hit Mr. Casey's father in 2016 looking for Mr. Casey and again made their threats. Mr. Casey alleged in immigration court that this was past persecution. The immigration judge and the BIA disagreed, and the Second Circuit affirmed. Although not before noting that the standard of review for past persecution cases is unsettled in the circuits, as between a very non-citizen favorable de novo review or the less favorable substantial evidence review. The Second Circuit didn't resolve this standard of review issue, but ruled against Mr. Casey, applying either standard of review, explained the court. Past persecution requires an aggregate analysis, requiring consideration of, quote, the cumulative severity of the alleged maltreatment, end quote. A pretty good standard for non-citizens, to be honest. And while we all know the case law that persecution is an extreme concept, non-life-threatening or even economic harms can cut it, explained the court. For death threats, explained the panel, in the Second Circuit, quote, an applicant must show that the threat was imminent or concrete, or so menacing as itself to cause actual suffering or harm, end quote. The court didn't see that standard met. I mean, you don't have to be killed. Again, death threats alone will cut it. But to the Second Circuit, its, quote, unfulfilled threats doctrine examines threats on a case-by-case basis, end quote. So what kind of death threats qualify? Well, ones that are, quote, imminent or concrete, end quote. The Second Circuit's doctrine requires to the panel aggravating circumstances showing imminence or concreteness, or that there was a threat, quote, so menacing as itself to cause actual suffering or harm, end quote. That's your standard, again, and that's an or. The concreteness or so menacing as itself to cause harm. The Second Circuit believes that its unfulfilled threat doctrine is similar to the law in all circuits, except the Fourth Circuit. Quote, only the Fourth Circuit treats death threats as persecution per se, end quote. Citing to Hernandez-Avalos v. Lynch from the Fourth in 2015. The Second Circuit doesn't see its standard met here. Quote, at core, Mr. Casey alleges that the Maoists threatened his life several times and beat his father once. While these are serious allegations, none of the surrounding circumstances indicate that the threats to his life were sufficiently imminent or concrete or menacing under our unfulfilled threats doctrine, end quote. Now true, recognizes the court, one of those threats involved like 15 dudes at his home. But Mr. Casey didn't point to anything aggravating during that event or anything close to an actual attempt. As examples that might cut it, the Second Circuit cites to case law where guns are displayed and pointed at people, but that was not done here. Similarly, with the violence against the father, quote, although violence against family members paired with death threats could amount to persecution on different facts, the attack on Mr. Casey's father was not significant enough, end quote. So, a past persecution decision, chock full of nuance and standards to meet in other cases, but not met here for Mr. Casey. And that is Casey v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook @Immigration Review, or send us a tweet @ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.